Hallo, guten Tag. Today we're talking about civil rights, and we want to begin with a reminder, a very quick reminder of the difference between civil rights and if you remember, civil rights refers to rights, freedoms that you are asking the government recognize that you're equal to others. In other words, if certain groups in society are being given rights or privileges that you've been denied, you're asking rather to be treated equally or fairly or be given the same sort of opportunities as others. Whereas civil liberties was asking simply for the government to stay out of, in other words, of our lives in certain areas, that there's these zones of privacy or areas where the government does not have a right to intrude or infringe upon. So we have to remember that distinction. Also, don't forget the 14th Amendment has two clauses that are associated with these ideas. Remember the 14th Amendment Equal Protection Clause. It's what will be the clause that we'll be focusing on here for civil rights, whereas with the civil liberties, it's more the Due Process Clause that's engaged because it's about the processes the government owes you prior to detaining you or how it should treat you.
This is just another definition, as Mr. Davila was saying, that the right to be treated equally under the law and the basis for that as it applies to the states comes from the 14th Amendment.
We'll see here that many great figures throughout history have made civil rights, if you will, the focus of their push, in that we've had throughout history various minority groups or marginalized groups that have not been able to share in the same rights and privileges as the group in power or as the majority. And here's a famous quote by Gandhi, who highlights that civil disobedience, meaning when you protest or when you refuse to abide by a law that you believe to be wrong, that is indeed, if you will, a high form of respect for the law. But in this case, Gandhi suggests that if you don't disobey a bad law, that's almost as bad. You're being complicit in the corruption and the lawlessness of the state if you're doing nothing to change it. That in fact, we have a proactive duty to rise up or resist or, if you will, counteract bad or unjust laws. That just simply not being the perpetrator of the wrong is not enough in terms of what's required of you in your moral obligations. So Martin Luther King is highlighting this in his very famous letter from a Birmingham jail. And he, again, whereas Mahatma Gandhi focuses on the fact that civil disobedience is indeed necessary in order to create a just and virtuous society, if you will, Martin Luther King builds on this idea and says, in fact, that when we break an unjust law, that's actually the highest form of respect that we can show for the law, because we expect and demand that the law be something just and virtuous. That in fact, law cannot be something unjust, and therefore we will not tolerate it in that form.
Okay, we have a short amount of time, so some of these slides we're gonna push through pretty quickly or just skip over, but we're gonna highlight some of the laws and cases that you need to know for the test. And so these are things to think about, but we're going to move on to the actual cases. So skipping ahead, and I think so. These slides are worth noting. I think when the government does discriminate, because remember there are laws that do discriminate, right? Discriminating meaning, one person is treated differently than another, or a certain group is, the law applies differently to different groups. And so actually discrimination or classifying groups in different ways is okay in some cases under U.S. law. And it kind of depends on the type of classification or discrimination that's taking place. And so when you look at some examples like age, race, and gender, they each have sort of a different level of scrutiny that the courts will apply if the government makes this classification. One of the least scrutinized forms of discrimination would be age. And in that case, they only have to meet sort of a reasonable standard. They have to have a rational basis for the law. Like, why is it that you can't drink until you're 21? You are discriminating in a sense, right, against people who are under 21, but there's a reason for it. The court will accept those laws as long as the government has a rational basis for the test.
And this is true even if if you will, reason or rationale is based in theory and that there is not concrete evidence. In other words, one could easily argue that, hey, I'm a much more mature 18-year-old than my 21-year-old brother. But the court and the government recognizes that at some point you just have to draw the line. And remember that courts are generally deferential to the political branches. And so in these close calls, or in calls where it's very difficult to know where the line should be drawn, they're going to give the benefit of the doubt to the government.
Okay, and then if you look at, say, skipping down to gender, that would be sort of an intermediate level of scrutiny that the courts apply. If there's some type of gender discrimination, the government has to show that, what's the standard? That it's there's basically that they have a good reason for it, but it's not put under as much scrutiny as say racial classifications, but it's more scrutiny than you would put for, say, age discrimination. So they just kind of classified these different levels that receive different levels of scrutiny. In other words, do you have a good reason? They're going to ask the government to prove why they have a law that applies to one gender, not the other. So you'd have to show kind of a higher level of basis for that than you would for, say, a age discrimination. And the one that receives the most scrutiny would be classifications based on race, religion, national origin, things like that, and those are considered inherently suspect. So the government would have to meet a very high standard in order to justify that type of discrimination.
So the two standards that Mr. Phillipps is alluding to with gender is that the court is looking for the state to show that its reason and rationale for passing that law is substantially related to the goal of that law. So, say age was only rational basis, the state only has to show a rational basis for having that law. The gender is substantially related, and whereas the race issues have a standard called strict scrutiny. And so strict scrutiny suggests that really there has to be a compelling state interest in order for the state's law to be considered okay. Whereas with gender, they would need to prove that it's substantially related, and whereas with age, they'd only need to show that there's a rational link. And so these are just degrees, matters of degrees, but they matter a lot. In this case, the benefit of the doubt with race cases actually is not. It's going to be actually not as, if you will, generous for the state for race issues. In other words, the court will automatically presume that there's something wrong with it. Where in these other categories, they won't. They understand that there could be rational bases for why you discriminate. For example, as Mr. Phillipps already put here in parentheses, but another one comes to mind that when we're talking about pregnancy leave or benefits or privileges that come as a result of being pregnant. Well, as a matter of science and fact, really, to the extent that we know, right, only women can be pregnant, and so there are going to be certain advantages that are going to accord to them that would not necessarily accord to a male, and that would be a reasonable thing.
Okay, so we're going to, I think, skip over a few of these things also. And, we talked about how the due process clause of the Fifth Amendment is different from the 14th Amendment in the sense that, until the 14th Amendment was passed, this was not seen as applying to the state governments. It was only meant to put a limit on the U.S. government, the federal government. And we know that the court narrowly interpreted the meaning of equality for many years, even after the 14th Amendment passed. Mainly what we're going to focus on here then are some of the laws and Supreme Court rulings that affect civil rights. And so the ones in blue are ones that we have not yet covered before this PowerPoint. The ones in black we have covered at some point. The amendments, you can flip through these next few slides to review these amendments that deal with civil rights in different ways. Of course, we have the one ended slavery. The 14th is probably the most important one to really focus on. And you can look through some of the others on your own. But again, the 14th Amendment is very important that you understand, especially the due process clause. Nor shall any state deprive a person of life, liberty, or property without due process of law is the 14th Amendment due process clause, which is the basis for civil liberties. And the last line, equal protection clause, is more the basis for our civil rights, or that's the part of the Constitution people use to bring their claims to the court or to the government that their civil rights have been violated. And, for many years, the court ignored essentially, or either ignored or very narrowly interpreted the meaning of equality, as we talked about. So for most of the late 1800s and through the first half of the 1900s or 20th century, the court did not, and the government did not really seek to enforce equality as we would understand it today. Remember that Plessy versus Ferguson sets up the notion of separate but equal, and that, which you could argue is inherently unequal, but for many years they said, well, that's okay. As it says here, the Jim Crow laws were allowed to exist in the South, and, so the federal government just kind of allowed that to happen, and the Supreme Court backed them up saying, it's okay to segregate the races by law, de jure segregation, by law, as long as technically the facilities for the different races were equal, which we know in most cases that they were not. And so again, Plessy versus Ferguson, just review that for the test, review this case, but we've already discussed this.
So, as we mentioned before, it wasn't until the 1950s with the Brown v. Board of Education case that overturned Plessy versus Ferguson that we see finally a full embrace of the 14th Amendment as it was originally intended. And in this case, we start to see legislation catch up with the adjudications that were happening in the Supreme Court. And the Congress...
Let's distinguish one thing. Yes, it did. It overturned, remember, only in the area of education.
Public.
So these other areas were yet to be, adjudicated in terms of, segregation was still legal in all of these other places. So it partially overturns Plessy versus Ferguson. But remember that Eisenhower and the Congress and the president weren't fully backing the court. We start to see that change in the 1960s.
And in particular, don't forget that with Brown v. Board of Education, that only overturned segregation in public schools. And so the question still remained, what about these other areas? And so it's not until the 60s that we see really the legislative branch catch up with the judiciary branch. And we start to see in the Civil Rights Act here of 1964, it made racial discrimination in public places like restaurants, hotels, illegal. And it also required employers to provide equal employment opportunities. And you can see here that the way in which Congress could enforce this, or the way in which they could leverage their influence here in making people comply, is that you would risk not receiving federal funds. They could be cut off if there was evidence of discrimination. And a lot of these institutions depended on federal funds in some form or fashion. So they had a monetary incentive to make sure that they complied with this law. In addition, we see the Civil Rights Act as well. It attempted to deal with the problem of the voting issue in the Deep South, where African Americans were still being disenfranchised. And so we see a subsequent law or act being.
And let me say one other thing is the remember that the Civil Rights Act was, did make a big difference, but what was the basis for that? And they had to, remember that the Heart of Atlanta Motel case, which is in your packet, but you need to review that for the test as well, where a hotel owner said, why does Congress, he challenged the fact that Congress, whether or not they had the authority to say that as a private hotel, owning his own hotel, a private business owner, that he had to allow African Americans or other minorities to stay at his hotel. And the court ruled that it was the Interstate Commerce Clause that was the basis, along with the Elastic Clause, stretching the meaning of the Interstate Commerce Clause was what gives Congress the authority to do this in the first place.
And so we see here in 1965, LBJ, Lyndon Baines Johnson, is realizing that, look, the Civil Rights Act is not going to do enough to really remedy all the problems and boundaries and, if you will, limitations that are put before especially African Americans in the Deep South. And so this particular piece of legislation removed the right of states to impose restrictions on who could vote in elections. And you'll see, though, that the Voting Rights Act was passed by large majorities in the House and the Senate, despite members from the Deep South opposing it. And it essentially empowered the national government to register those whom the states refused to put on the voting list. We start to see, unfortunately, I think, as time goes on, there is fluctuation in how this particular act is going to be employed. In fact, recently a Supreme Court case allowed for certain states that had a history of discriminating against certain groups when it came to voting. Let me back up a little bit to explain what I mean there. Under this act, it empowered the federal government to monitor the actions and the policies that states, especially states, or in particular states who had a history of discriminating against certain groups like African Americans, they had to submit any law or policy that had to do with changing electoral rules in their state to the federal government to get verification and confirmation that it was okay prior to passing it. And in a recent court case not too long ago, they actually struck down that portion of the Voting Rights Act. And that was a very controversial move, especially considering that Congress had just finished reauthorizing it. And the court comes back and says, well, we're going to say that these states have proven that they're no longer openly discriminating against groups, so they no longer need federal oversight when passing their particular laws or rules regarding voting.
Right, and I think I don't remember the case name, but yeah, I mean, so, and we've seen, that some states have taken advantage of this already in the South, but also other parts of the country that weren't even under this law. But I think, states that were put under federal watch basically would be states that use things like literacy tests or other such means, to keep people from voting. And so it was basically most of the states of the former Confederacy, including Georgia, that were put under this federal watch. But the next few slides will show us how successful this law was. It really was a very impactful law, and it did lead to large increases in registration of African Americans, and the southern states basically were forced to do this. They knew otherwise. They didn't want the federal government to come in and take over their voting procedures, and so they finally complied. And so you see here, this just shows the percentage increase in registration. You see, for instance, in Mississippi, a 695.4% increase from 1960 to 1966. I mean, that's a tremendous change in thinking that considering the law was passed in 1965, but you see other states, Alabama, Georgia, 66.7% increase. So some states were more, we're practicing even more discriminatory practices than others.
Yeah, like Virginia, much more so than Georgia. Just wanted to point that out. But, go.
And then you see here also just evidence of the effectiveness of the law as the gap between black and white registration narrowed significantly. And in the case of Louisiana, actually, African American registration exceeded white registration by 1988. And then, again, this shows that, the number of legislators that have, increased in terms of African American representatives. I had a student ask, actually, Neeraj, shout out to Neeraj, first period today. Why were there so many African Americans, at least for that brief period in the 1860s and 70s? And that was because that's the period we call Reconstruction, which you'll learn about in U.S. history. But basically, at that point, the southern states were forced to allow African Americans to vote and be elected. But once the federal troops left at the end of the Reconstruction period, you see 1876, huge drop off, and after that election anyway. But you'll learn about that in U.S. history. And again, just further evidence of the success of the law in terms of how many African Americans were actually elected in those 11 southern states that mainly were affected by the Voting Rights Act. A further, 24th Amendment, again, poll tax was another method that they used in the South to try to keep people from voting, especially African Americans. And this was banned by the 24th Amendment. No more poll taxes.
So in this case, we have a situation that's sort of going to highlight how the sort of NAACP sort of was tackling the issue of segregation. So the NAACP, the National Association of Colored People, if you will, they were looking at how it was that they were going to dismantle the segregationist and racist laws throughout the South in particular, but throughout the country. And part of their strategy was to first look at the most sympathetic situations, and you could tell, or the situations where there were really no viable alternatives. And one of those areas was clearly higher education. In other words, it was a lot easier for them to sort of construct regular public schools, say for everyone, but much more difficult, time-consuming, and involved to try to create equal universities, especially ones that are specialized like in law or medicine. So we have an applicant, Herman Marion Sweat, who was a black man who tried to apply to the University of Texas Law School, and the law restricted access to the university only to whites. And he sues. He said, and the question presented before the court was, did the Texas admission policy violate the Equal Protection Clause of the 14th Amendment? As you may expect, in a unanimous decision, the court held that the Equal Protection Clause required that he be admitted to the university. What happened in Texas, they tried to get clever in order to avoid having to allow blacks into their law school. They tried to commit. They said they would commit to and create an institution, but that was for blacks. And the court found that the law school for Negroes, as the term was then, which was to have opened in 1947, would have been grossly unequal to the University of Texas Law School. In other words, it's rather clear there would be no way to sort of match the prestige, the facilities, the resources, and the connections that come with having been or enrolled in the University of Texas Law School. So it's interesting that the court uttered mentioned in that last case in Sweat that the mere separation of students by color created this aura or air of inferiority and superiority, and that was problematic. Why that's so telling is because we're going to find that in Brown v. Board, which we already discussed. That's precisely what they harp on and find to be problematic. Now, there's a difference between de jure segregation and de facto segregation. As we know that by 1954, but especially by the time that we get into the 1960s, there were pretty much no more laws that were explicitly racist or segregationist. In other words, most of them have either been struck down by the court or, if you will, undermined by law or gotten rid of by law. Now, so while it's true that de jure segregation may have been rooted out, the reality was that that didn't stop segregation from continuing in other ways. And de facto segregation just means as a matter of fact, whereas de jure means as a matter of law. But de facto segregation was something much more difficult to root out. And in fact, we see that while the law did not allow for segregation, people could still be racist and segregationists. And in particular, we saw these attitudes express themselves and manifest themselves when we were looking at housing patterns. That means real estate agents oftentimes would, if you will, steer people to some neighborhoods versus others. And I believe in AP Human, you guys talk about steering. And we talk, we'll talk here obviously about it as well. The idea is they would say things like, I think that this neighborhood is more suitable for you, right? And they wouldn't say necessarily, well, this is a white neighborhood or this is a black neighborhood. They would use code language. And that's what we have to be on the lookout for, is that oftentimes, if you will, segregationist or racist policies, they may not, or discriminatory policies that are unconstitutional, they may not be as open or blatant anymore, but that's why we have to look out for this coded language as well as patterns of behavior.
And of course, our current president and his father were also brought up on, or were fined, I believe, for admitting to, or had to pay a lawsuit, I believe, settlement, because they basically were found to have been discriminating in housing as they were renting apartments. They apparently would put C next to certain applicants who were colored, as it meant back then, people who were minorities, and they were finding themselves denied in their application to live on certain Trump properties, and that got them into some trouble. The Swan versus Charlotte Mecklenburg case, I believe, comes up in the next few slides, but just noting that's where I was born, Charlotte Mecklenburg County, and I was born December 1970. So this case actually was decided shortly after my birth. And if you go to Charlotte today, you'll see a monument to my birth in the city. Now that may or may not be fake news.
All right. So after the Supreme Court's decision in Brown, there had been little progress made in certain areas. If you recall, in the Brown case, there was Brown v. Board 1 and there's Brown v. Board 2. And remember that Brown v. Board 2 was all about what was the proper remedy. How were we going to, or how was the court going to implement this ruling? And remember, they tossed it back to the localities, but they added language with all deliberate speed. And some areas we know we're going to drag their feet or practically do nothing. And then the question would be, well, okay, the federal courts now can intervene, but to what extent can they intervene? So in this case, we had a situation where North Carolina school system, which approximately 14,000 black students attended schools there, and they were either totally black or more than 99% black. And the question was for the court was, were federal courts, were they constitutionally authorized to oversee and produce remedies for state-imposed segregation, and to what extent? And in a unanimous decision, the court held that the courts, in fact, were empowered to implement remedies, and they were rather broad in many ways and flexible what kind of remedies they could put in place to right certain past wrongs. And you can see here some of the things that they could implement or use in determining how to identify if there was still problems with implementing the decision, and what kind of things they could do to make the decision, or rather rectify that situation. So I didn't mention, but in the last lawsuit, busing was a major issue, where they would be busing students from certain schools, frankly, white schools or white neighborhoods to black neighborhoods, or sorry, to black schools and vice versa. So just keep in mind that the busing policy or option was a rather controversial one. There was a lot of controversy because it really, at that point, was the way in which you could also tackle and target de facto segregation. But for many people, taking them outside of their comfort zone, taking them outside of their schools was a very disruptive moment.
We tend to focus on, African American rights in a lot of our studies of history, I think, because, that got typically more media attention and so forth, and maybe more high-profile figures that Americans were familiar with, like Martin Luther King Jr., for example. But of course, other minority groups faced discrimination, equal to, in some cases, maybe even worse than African Americans. And so you see some of those groups here, such as Asian Americans in Korematsu, when they had to go to essentially, concentration or military camps during World War II, simply because of the fact that they had Japanese heritage or were immigrants, but many were citizens. Hispanic Americans, of course, have had and maybe continue, today to fight in many ways, still fighting for rights, for equal rights. And then Native Americans, of course, have faced many injustices in their history, since the beginning of our history.
In the Korematsu case is very interesting. World War II was happening, and FDR issued a presidential executive order because what happened, of course, if you may know or if you don't know, that Japan struck first at Pearl Harbor, and this really struck fear in Americans because we had never really been, it had been a very long time before any foreign nation had attacked us on our soil. And so many people were unused to this and completely unfamiliar to it. And so the president issued this order, but were sued. Basically, they had these sort of concentration camps for Japanese Americans. Now, notice they didn't have those concentration camps for German Americans. Germany was certainly, in some ways, just as much, if not a bigger threat to the United States. And this was clearly, there was some racism and cultural bias at play here. But the question before the court was, did the president and Congress go beyond their war powers by implementing this exclusion and restricting the rights of Japanese descent? The court sides with the government and allows this to happen and suggests that the rationale, the basis for their decision here was that a military necessity during wartime allows us to outweigh Korematsu's rights. And so in this case, you can see the circumstances of emergency and peril justify, if you will, this compulsory exclusion. But nonetheless, you can see here Congress authorized token compensation for loss of property and violation of rights. In other words, they were trying to right a wrong and said, we're sorry that we discriminated against those who were interned or their families. So coverture, women's rights obviously too, women obviously were not treated equally. All of these are groups that have been marginalized or somehow discriminated against throughout our history. And this was a particularly problematic sort of policy, or if you will, principle that ruled a lot of case law, essentially made married women subject to their husbands. And that meant they couldn't sign contracts or dispose of property or have their own credit cards. The divorce laws in child custody cases automatically favored the husband. And this was true all the way out up to the sort of 19th century. But even into the 20th century, we still saw signs of this kind of bias. Therefore, you see the passage of the 19th Amendment, which finally gives women the right to vote. Notice that women don't get the right to vote till, decades later, even after African American men got the right to vote. That just citing another group that had been marginalized. But if you can imagine, here we have even a group that was further discriminated against. The Equal Pay Act, of course, was attempted here to prevent businesses from discriminating on the basis of salaries due to gender. And, well, we know that did not pass in terms of the Equal Pay Act. That did pass.
Yeah, the Equal Rights
Equal Rights Amendment. Sorry, we'll get to the ERA in a moment. Pardon. The Equal Pay Act does pass. The Civil Rights Act, of course, had a gender clause. That has an interesting backstory, though. The gender clause in that situation was actually an attempt to scuttle the bill. I believe it was a Southern senator who did not want to see the Civil Rights Act passed, I think it was added language, and they thought certainly this won't pass if we put that women should be treated equally too. So this was a rather, if you will, interesting backstory to how that clause gets in there. And then we have also the court cases of Reed v. Reed and Lilly Ledbetter, and we're going to get to those here in just a moment. So in the Reed v. Reed case, this is an interesting situation where these two individuals, Sally and Cecil Reed, had adopted a son and he had died, and they both sought to be named the administrators of their son's estate. They were separated at this time. So Idaho probate code specified that males were to be automatically preferred to females in appointing administrators of estates, and therefore Cecil was appointed as the administrator. And Sally challenged the law in court because the court didn't even bother looking at any of the facts or any other of the circumstances when arriving at this conclusion, and argued that this was essentially a violation of the Equal Protection Clause of the 14th Amendment. The court, in a unanimous decision, sided with Sally. And then in this case, you can see the court argued that to give a mandatory preference to members of either sex or over members of the other, merely to accomplish the elimination of hearings on the merits, is forbidden. In other words, automatically giving preference to one group without any basis in fact, without any consideration for the context, is not permissible and is indeed a violation of the Equal Protection Clause.
Yeah, so here's the amendment that Mr. Davila was referencing, that there was a big push to pass the Equal Rights Amendment. You can see the wording, what the wording would have been, the essential part, which says no state in the United States or the government of the United States can discriminate based on the account of sex, meaning gender in that case. So it did pass Congress with I believe large majorities, but then it stalled as it went through the second process, which is ratification by the states. Remember, 3/4 of the states were required to ratify, and they never reached that mark. They got to 35, and if you look at the states who did not approve it, there was a very very clear picture on a map of the United States of which states did not ratify. And you probably can't guess, but I'll give you a few seconds to think which states would not have favored this. And yes, indeed, it's where we live. The southern states refused to ratify, and it never did pass. It never passed. So, and then they've also attempted to rectify inequality in educational opportunities, including athletics, with this famous clause or section called Title IX in the Education Amendment Act to the Civil Rights Act, I believe. And so that requires equal funding for athletics for women and men. Lilly Ledbetter was a woman who worked for Goodyear, the tire and auto company, or tire company, I guess mainly they're known for. And she found out later that she was receiving less pay for the work she was doing, and compared to her male counterparts who had similar levels or at similar levels within the company. And so therefore technically they were violating the Equal Pay Act, I guess, but they ruled in the Supreme Court, the conservatives of the court basically ruled that she did not have a case because she did not file her complaint within 180 days of when the discrimination first started to occur. But she was not aware that she was facing discrimination because they weren't allowed to talk about their compensation. And so once she found out, she sought back pay, and I believe originally it was awarded to her, but the Supreme Court overturned that. And so when President Obama came into office, the first major piece of legislation that Congress passed and Obama signed into law, you can see the picture there, and I believe that's Lilly Ledbetter standing to his left above him. But anyway, so they say that every time you face discrimination, the 180 days resets. Every paycheck that you receive that was not fair would reset your 180 days in which to sue.
And I would add just that the liberal dissent in this decision, Justice Ginsburg wrote a scathing dissent that actually instructed Congress how they could remedy this. And this was an interesting dialogue between the judiciary and then the legislative. She said, you know, if Congress wishes to rectify this wrong, they could pass this kind of legislation. And lo and behold, that's what the sort of more liberal members of Congress did.
All right, I'm going to continue our presentation solo here. We ran out of time, so I'm going to finish it up. So men and women, there are laws that apply differently. In some cases, for instance, only men must register for the. This was brought up in this case of Roster versus Goldberg. And anyway, in that case, they ruled that it was okay to have separate application of this law to men, that men would have to register and not women. You can see here that this was not deemed to violate the Due Process Clause or the Equal Protection Clause, and anyway, so that they're not similarly situated for the purposes of draft registration. So I guess sort of a bias against women, although today, of course, women can serve in the military in full combat roles, which was only a recent change. As far as age, you know, there are some rights to protect elderly people from discrimination, from age discrimination, but there are certain things that you could restrict based on age, such as maybe a mandatory retirement age in some cases, perhaps for instance, for airline pilots. As far as gay rights, that's a ongoing issue, you know, the courts are dealing with. I think just maybe a day or two ago, they heard a case about a person who sued, saying like he didn't want to, you know, he got in trouble for not being willing to bake cakes for a gay couple for their marriage or provide a cake for that, and that the court just heard arguments in that case. So it's kind of a evolving issue. For a while, they followed this policy of don't ask, don't tell for the military, but that was abandoned, and President Obama now put into effect that gay people can serve openly in the military, although currently, you know, President Trump has faced some controversy with his announcement that he wants transgender troops to be banned from the military. So like I said, it's kind of an ongoing issue that the courts are dealing with. The most recent case that you need to have in your case packet as far as gay rights, the most recent landmark case was Obergefell versus Hodges. There was a law at one point where, you know, the federal government recognized marriage only between a man and a woman, and of course many states had that law in place as well. Some states started to legalize gay marriage, but with the case of Obergefell versus Hodges, a gay couple, I think in Ohio was the lead case, and two men that thought their equal rights were being violated by being denied the right to marry, and the court agreed, saying that if you deny someone the right to marry, even if they're of the same gender, that was a violation of the 14th Amendment, and that, so therefore, you know, this case overturned all of the states' bans on gay marriage that existed. And so now it's legal in all states for people of the same gender to get married. We talked about racial discrimination and gender discrimination that, you know, existed through much of our history. And as they tried to even or end those laws that discriminated in hiring and in education and so forth, you end up with this question about affirmative action. Should the government take action to promote the people or help the people who faced legal discrimination in the past? You can't just level the playing field and expect all of a sudden that people will be on equal ground, because, you know, people have been held back for many years. And so a couple of these cases we're going to look at that deal with affirmative action as it applies to education. In this case, Regents of the University of California versus Bakke. Alan Bakke was an older, as far as a medical school student, he was on the older side, 35 years old when he applied, and he was rejected. He found out that his qualifications exceeded those of some minority students who were being admitted into the school. What the school had done was set aside 16 spots, as you can see, out of 100 for minorities only, and so he was more qualified than the minorities who were being admitted in this affirmative action program. And so he said that he was, he kind of takes the 14th Amendment and flips it around and says this is a violation of equal protection because, in a sense, it's reverse discrimination, and that he was being banned or, denied admission to the school because of his race, that being white was working against him. And the court issued sort of a divided ruling or sort of a fractured ruling in this case, but they did say that this program was unconstitutional, that the rigid use of racial quotas was unconstitutional and violated the Equal Protection Clause. However, they did rule that race could be used as a factor, so they left the door open for future cases where race could be considered as a factor, but you couldn't have a strict quota type program where you, for instance, where you'd set aside specific spots for those racial groups. So this comes up again several years later in the case of Gratz versus Bollinger and Grutter versus Bollinger, two cases involving the University of Michigan, one with the undergraduate school and one with the law school. In this case, I believe it was a female student who was also white, and Michigan had a policy of, again, trying to attract more minorities. It says from specific group, African Americans, Hispanics, and Native Americans that were underrepresented on campus. So they were seeking a more diverse student body, which you could argue, enhances the educational experience for all of the students. And so they had a policy where I believe, I believe it was you needed like 100 points to get into the school in their admission scale, so you got points for different attributes. And I believe being a minority in one of these three groups that you see here, automatically, I believe, gave you 20 points, I want to say. And so you were already like 1/5 of the way to the automatic amount of points you needed to be admitted. And so anyway, Gratz felt like this policy discriminated against her, and again was claiming sort of reverse discrimination under the Equal Protection Clause of the 14th Amendment and Title VI of the Civil Rights Act for opportunities of equality in education. And in this case, the court said that Michigan's policy, University of Michigan's policy, did violate the Equal Protection Clause, and as you can see here, I guess I was correct, but the 20 points given to these minority groups was not narrowly tailored to the goal of creating more racial diversity. In other words, it was too broad and gave too much of an advantage to someone simply because of their race. And so they struck down this particular policy, or this, sort of quota system. In Grutter versus Bollinger, they also challenged, it was another challenge to this case, Michigan's law school policy. And again, they were seeking more diversity in their law school. And so they considered race as a factor in admission, but they didn't have that rigid, 20-point bonus like they did in the undergraduate program. It was more of just a general notion that they were actively seeking more diversity, therefore race would be considered sort of a bonus factor, but not any specific, there wasn't any specific number or, quota or something that they were trying to achieve. So did this violate the Equal Protection Clause of the 14th Amendment and Title VI of the Civil Rights Act? And in this case, again, you see the court very divided, but they said this was a more narrowly tailored use of race to achieve a legitimate goal, which is a more diverse student body. And each applicant was looked at individually, and there was no automatic or like super bonus given because of race. But that, race was considered as one factor among many others, such as perhaps your GPA or, your, leadership activities, your school, maybe your LSAT scores, the law SAT that you take to get into law school. So that race could be considered a factor. And think of it this way: if two students were pretty much equally qualified in terms of their grades and their college performance, their LSAT scores, and let's say there's one spot left in that school, and the incoming first-year law students are mostly white, for example, and you had one spot left, and there was an African American or a Hispanic candidate who had applied, and then a white student, and they were basically equally qualified, you could then, make sort of the tie-breaking factor, the fact that someone is from a minority race. So in that case, that would be acceptable. So to wrap up, I would say what they decided is race can be used as a factor, but not the factor, not the deciding factor. It can be used as one consideration amongst many when you're reviewing applicants for college. But there can't be like a rigid quota system or like a huge bonus given based on race. The Americans with Disabilities Act, so people with disabilities obviously sometimes would face discrimination in trying to get jobs. And this was a big step forward for people with disabilities, saying that if you have a disability, but you can do the job that you're applying for, the company hiring cannot discriminate based on your disability as long as reasonable accommodations could be made. So for instance, let's say you're in a wheelchair, but you're perfectly mentally capable and you're skilled at computer programming, and maybe they would need to design like a special desk or something to accommodate your wheelchair or whatever, that would be a reasonable accommodation. And they couldn't say, we're not going to hire you because we don't want to deal with the inconvenience or something like that. So it's a good law to protect people with disabilities from discrimination. And that's just Bush signing the law, first George Bush. All right, so here's some more details on that. Again, if you're qualified, as long as it can be with a reasonable accommodation, you should be able to get the job without any type of discrimination or your disability being held against you. And here's some more details on that.